All rise. Judges of the court. Hear ye, hear ye, hear ye. All persons having business before this court of appeals, held in for the state of New York, may now draw near, give their attendance, and they will be heard. All please be seated.
Hey, good afternoon, everyone. Before we start, our colleague Judge Feinman is participating in oral argument today remotely. Good afternoon, everyone. This is appeal number 31 on the calendar, matter of Paul H. Senzer. Counsel?
May it please the court. My name is Michael Blakey. I'm of counsel Dave Besso, who is the attorney of record for the petitioner, the Honorable Paul Senzer. The question before this court, simply put, is whether removal is the only possible sanction upon the facts that were sustained by the commission below. It seems that the CJC and their counsel have jumped logically from the use of vulgar language to apparently an obvious finding of gender bias. I have to say that that's a little bit too far, and in fact, they go further than
counsel,
that.
it depends on the type of language, right? Whether or not it reflects gender bias, because certainly, if I may, in the employment discrimination context, particular type of language may indeed reflect, may be the basis for a finding of sex discrimination and gender bias.
Of course, word choice is a factor, as is context. But they go further than saying there's obvious gender bias. They say there's a pattern of gender bias. So that's another logical leap, which I can't join them in. We don't think the gender bias is obvious, and we don't concede it. And we could go into multiple interpretations of the words used. I don't think that's necessary. I mean, I can just point out the worst one, the use of the C word. But it's not a C word by itself. It's a term of art, C on wheels, which obviously refers to the aggressiveness of that attorney. It's a left-handed compliment, is one way to look at it. It's obviously inappropriate. Let me take a time out quickly to say that we're not offering a defense or a valid excuse for these words that were used. But it's still relevant for us to discuss the context of the words used for purposes of mitigating the punishment. I would note that the referee report had a finding that the legal profession was brought into disrepute by the use of vulgar language. He didn't jump to the gender bias conclusion, and he didn't jump to a pattern of gender bias conclusion.
So, counsel, your view is that the language itself, putting aside gender bias, wouldn't be sufficient for removal. Is that right?
The language, the choice of words is not sufficient.
Well, Counselor, can I just follow up on the judge's question? Is it fair to say that you don't contest the fact that this conduct violated the conduct rules?
I have to put an asterisk on my answer.
The reason I ask this, let me explain. I'm not trying to trick you into something or have you admit something that's contrary to your client's interests. Is your argument really that the penalty is too harsh for the conduct? That's your argument, isn't it?
That
your
is my
argument
argument.
isn't that he didn't do this or that...
No, he conceded all this. He was candor and contrition are part of the record.
So we don't even need to really spend a lot of time on whether or not there was, you met the legal threshold for these rules to be imposed in this situation. It's really a question of, does the punishment fit the crime?
Exactly, Judge.
I see. Okay.
So you have a situation where removal must be based on someone who is found unfit to be a judge. And the case law says that it's not enough to exhibit poor judgment, and it's not enough to exhibit extremely poor judgment. You have to go further. And Look,
Well,
some
what about when it impacts respect for the court system and the judiciary and lawyers and that sort of thing? Does that make a difference?
That's just one factor among many that should determine what the appropriate
But if
sanction is. It's not controlling.
If it's serious enough, that one factor, I guess I'm asking, could that one factor be enough to warrant removal?
I would say no, it's a multi-factor analysis. Look, I want to
And
go
Counselor, it
to...
wasn't said once, right?
What?
It was said multiple times.
No, different words were used in different times. The C word was used that one time.
No, but the various words were used. When you say there's no pattern, but there is at a minimum a recurrence of the conduct.
I'll give you a recurrence.
Of using words that are disparaging to females and using other words that are also problematic because of their profanity or body parts that they're referring to, correct?
Right. But in context, they were all towards one client and her husband, and they were all by email. I would like to bring up a case that I think is very important. It's called Cunningham. It's cited in the brief, and it's discussed by both sides. In that case, one judge wrote to another judge in a private correspondence twice and promised him he would never reverse him. It was conceded that that was improper to do. However, those letters only came to public attention after bizarre circumstances which could not have been anticipated. And I would say that that factor applies to Judge Senzer. He had no idea that this was going to go on beyond that. You can say, hey, you send an email, therefore it's public, but that's not the end of the analysis. This is not on the bench conduct.
I don't know that your best position is to say he didn't think he'd get caught.
No, but I'm saying that you have to look at how the conduct was intended.
But
He
the
did not
difference-
intend
an
for it to be
important-
public, and
an important-
that's
excuse me,
relevant.
Counsel, an important difference in Cunningham is that there was factual evidence demonstrating that the judge actually reversed the other judge, right? So that you could tell.
Oh, in Cunningham, that did happen,
Right.
so maybe the words,
So the analogy here would be if we had evidence that Judge Senzer was not gender biased, then maybe it's sort of parallel, but we're missing that here, aren't we?
wait, did you just ask me if there was any evidence that he was not gender biased?
Correct.
I'd say yes. In the record, almost 20 years of no problems. I will point out that that 2001 situation was a letter of caution with dismissal for lack of judicial decorum. Did not get into gender bias. They've inflated it to be gender bias because the people he talked about were women, but the statements that he made were not specific to female women, the persons that he was addressing. So his intent, it can be found relevant to what his appropriate sanction is. This is not on the bench. This is not in chambers. This is not off the record as far as in courtroom, and it's not in a public bar. For some of the cases that were cited by my opposition involve judges in public outrageous displays, and that's not what happened here.
Counsel, I guess the problem I'm having is that Judge Senzer and his representation of this client denigrated every stakeholder in the system: the litigant, the litigant's lawyer, the court attorney, referee. He disparaged the entire system. And he was making those statements as an officer of the court and as a person who is a representative of the very system that he, over the course of his representation, continued to denigrate and disrespect. How do we fall short? How do we justify continuing his service on the bench?
We're not justifying it. We're saying what's the appropriate penalty.
Oh,
I'm
that's
saying
what-
that
that's
conduct's
what-
wrong and
if
should
you're
be censured publicly.
But how do we keep a person who has engaged in that conduct on the bench? What would we say censure is enough to erase all of the damage that's been done? Is that what we say? And put him back on the bench to preside in a public courtroom over hundreds and hundreds of litigants' cases?
Well, I would welcome an ad hominem analysis. This person came before the hearing. He was contrite. He exhibited candor. He has a long record of being a great judge. There was character witnesses that impressed the referee. All that's in the record. This is not a vacuum. So we have the bad use of language, which he regrets. And now the question is public censure sufficient? And I would imagine that it is. So the factors that would lead anyone to, well, particularly you judges, to reduce the recommended sanction of removal down to censure come down to 4 elements, it seems to me. One is, this is mitigating factors. Career as a whole. He has a great career as a whole, and the character witnesses establish that as well. 2, his motivation for using these bad words. He didn't do this to make money or anything like pecuniary. I mean, his explanation, weak as it was that he was trying to speak in a vernacular for emphasis, for persuasion. There are no good reasons, but they're reasons, and they're not monetary reasons. 3, candor. Now, the fact that he doesn't want to accept removal does not mean that he lacked contrition. So candor and contrition are 2 sides of the same coin. He was both. So all of those factors are in his favor. I did forget to ask for 1 minute of rebuttal. Is that still available?
I reserved you a
Thank
rebuttal
you.
minute. We'll give you a minute. Thank you, counsel. Counsel?
Thank you, Your Honor. Good afternoon, Chief Judge DiFiore. Good afternoon, Your Honors. May it please the Court. I'd like to begin by addressing counsel's point with regard to gender bias, because I think the record fully supports the Commission's determination in that regard.
Counselor, I'm just having a hard time hearing you. Pull that mic a little towards you. Thanks.
Yeah, I can hear
yeah.
that.
That's not usually a problem for me.
No, I know.
So I wanted to discuss the gender bias determination by the Commission, and I asked the Court to start at page 398 of the record, which is a portion of the petitioner's testimony during the Commission's investigation. And he was specifically asked whether or not he thought the words that he used in the November 25th email might suggest that he harbors a bias towards women or women lawyers. And he testified that he certainly understood that it did. And I think it's obvious that that's true. This is a word...
Mr. Lindner, how much weight should we give to his reputation and his career as a whole in this regard, and to the character witnesses, all of whom said that they had never seen him act in a gender bias fashion,
Well, if I
and
may,
that this
Judge Stein.
was very uncharacteristic of him? How much weight is that entitled to?
It's always a factor, and this Court has to look at every factor. But in terms of his career, I don't think that it's enough to overcome the obvious gender bias in these emails. With respect to the character witnesses, though, I have to say that and we argued this below, that the testimony was largely improperly admitted. It was not reputational witness or testimony. It was testimony that these witnesses had never heard the petitioner use these kinds of words. And I suppose it's laudable that he didn't use this kind of language when he was sitting in court, which is the only place that 2 of those witnesses saw him, or that he used it in front of his Monsignor in religious class. But it obviously doesn't prove that he didn't use this language because we have the emails. And so I don't think that it was particularly probative and should have been disregarded, and was disregarded by the Commission. But I wanted to get back to the gender bias, if I could, for just a minute, because it's not just that word. That word is certainly significant. This Court has called it vile and reprehensible. The 11th Circuit called it the essence of a gender-specific slur. But there are more, as Judge Rivera was pointing out. There are 3 emails in which he uses a gender-based slur, profanity, to refer to the Coleman's daughter. And then there's an email, a 5th email, in which he refers to his opposing counsel as eyelashes. Now, it's admittedly not on the same par as the profanity in the other emails, but it's nonetheless sexist, and the Commission determined that it was. It's reducing a woman, a female professional, to her appearance, which is the kind of thing that's rarely, if ever, done when we talk about a male professional.
So let me try my question on you as well, which is suppose that these, I'm not sure what equivalent would be, but suppose he had instead made equivalent derogatory comments in the same volume about a man, right? So we're not any longer talking about a gender issue. Would the language have been sufficient for the commission to recommend removal?
Well, I think the answer would have to be yes, although I have to admit, Judge Wilson, that I also don't know what the equivalent would really be that would have quite the history of that word and the gender sting that it carries. But yeah, any language that over a period of time conveys disrespect or bias based on a characteristic like sex or race, and any language that denigrates the court system as a whole is problematic.
Counselor, let me ask a slightly different question, and that's about the nature of the circumstances under which these comments were made. I would never do this, I promise, but what if I said something uncharacteristic of myself to my spouse in an email about somebody, okay, in the system, and sometime down the road, my spouse decided that he wanted a divorce and publicized these inappropriate comments I made. Would that subject me to removal
Almost
from the
certainly
bench?
not, Your Honor. Let me point to the Commission's determination, this is at page 8 of your record, where they say explicitly, right up front, that the use of profanity in communicating with a client is not an issue in this case, nor is criticizing participants in a legal proceeding. And they emphasize that again on page 13 of the record, where they say the occasional use of profanity or vulgarity, the occasional use of sexist terms, that's not what this case is about. This is about a pattern of comments over a period of months which demean women and denigrate the court system as a whole.
Counsel,
So
on that point, what's your view of the import, the relevance of the O2 caution here to the penalty?
it's not the same, but it's clearly not unrelated. Here again, you have the petitioner making sarcastic and disrespectful comments. He is making them to women, although he's not using the same sorts of gender-specific slurs. And there is the portion of that caution letter which points out that in several times during that proceeding, the petitioner went off the record trying to keep his comments from being recorded and suggested he knew at the time that he was speaking out of turn and he didn't want to make a record of that. And you see an echo of that here, where in his November 25th email, he says, "Don't quote me. Don't quote me." He knows at the time that what he's saying is not correct. And he knows at the time that this is the kind of thing that people talk about, that this can spread. So I disagree with counsel's assertion that he had no way of knowing that this language would ever come out, because he testified differently to that during the hearing.
So the
He said-
bar for removal is high, is that correct?
I'm sorry?
The bar for removal of a judge is high.
It's absolutely.
So I've struggled to find a case where I would say, well, this case, if we come out the way the commission has come out, wouldn't somewhat lower the bar. Is that, I mean, I'm not saying that lowering the bar isn't a good thing.
I understand the question, Your Honor. And let me ask the court to take a close look at the facts in Assini. They're not exactly the same, but the first portion of that determination or your decision is really quite close.
Yeah, but the
He has-
second portion is there too, and that act to me is the more troubling, that after having been told not to have the driving school guy in court dictating who's going to get referred to this guy's own driving school, the judge continues to do that. Seems to me by itself is a reason to remove it.
I'd readily concede that, Your Honor, but I'm asking you to focus on the language in your decision in which you said that the use of the gender slurs indefensible, and by itself it suggests that that judge was unfit for judicial office. And you have someone using the same words here. And let me point out that Assini now was 20 years ago. It was certainly wrong for Judge Assini to use those words in 1999, but no judge in 2020 should think that that's acceptable conduct.
So, back to the point that Judge Stein had asked about before, how do we weigh the context of the communication? The way I and you can correct me, you know the record better than I do, but the way I understand the charge is that it was a lost case, and there was a dispute about the fee, and then the emails and all this information came forward in the context of a complaint to the commission. Is that correct?
Well, I'm not sure if you have the timeline correct or if I misunderstood
Correct
what
me
you're
then.
saying. But
It's fine. Just
what
correct
happened
me.
was that, there was a family court matter in which he was representing the Colemans, and all of these emails came out there.
And but it was afterwards, there was a dispute. He said that they wanted their money back because they lost, and they didn't get it.
And that was a finding by the commission, but I would treat that fact with some caution. If you look at the record underlying that, the petitioner never claimed that the Colemans were angry with him. He never claimed that they wanted a refund. That came up only because Ms. Coleman volunteered it on cross-examination, and she didn't say that she was angry as well. She was asked, why did you contact him? And she said, I wanted to talk to him about a refund. So it's a fact in the record, it's true, but I don't know how much weight you can give it. This actually came out, and it's a little convoluted, because the Colemans read in the newspaper that the petitioner was the subject of a civil rights suit involving different people in a different situation, and they felt that the information that they had regarding his comments were relevant to that, and so they contacted the attorney who was representing those other clients, and that attorney felt obligated to report that to the commission.
It
A little
does seem
convoluted.
odd, though. It does seem that there is some retaliation involved.
It's possible, and honestly, Your Honor, that comes up a lot in our business. The fact that a complainant may have an axe to grind doesn't really bear on whether or not he or she is telling the truth. And here, there's no dispute. We have the emails.
Thank you, counsel.
Thank you, Your Honor.
Counsel, your rebuttal.
Yes, I'd just like to make one point about plenary review. Now, obviously, you guys get to look at this de novo. However, I would like to point out that you can reassess facts that were sustained below. I don't believe that plenary review allows you to revisit facts that were not sustained below. I think that's an important point, because the dissent took the position that if somebody makes a sexist remark, they're more likely to also be a racist. I don't believe that's logical.
Thank you, counsel.
Oh, just my closing remark, one sentence.
Please.
Public censure is a very serious sanction which fully expresses the necessary amount of societal opprobrium and clearly establishes that all forms of extrajudicial speech can have profound consequences. Thank you.
Thank you, counsel. Thank you.